For a moment of prayer. Dear Heavenly Father, we call on you now, asking for your guidance and your wisdom. Lord, we know that we live in trying times and we have difficult issues that are brought to us to deal with. And Lord, I'm reminded that your word is a relatively small document compared to our code, the laws that we live under today. And if we had only followed your basic laws, Lord, we probably wouldn't be dealing with a lot of the issues that are before us today. But Lord, we are where we are. We ask for your wisdom, your guidance, and your blessings on this meeting. In Jesus' name we pray, amen.
Before we jump into the agenda, for those of you here for Senate Bill 221, the Religious Freedom Restoration Act, that is scheduled for hearing only if we have time available to begin it. We have 6 other bills that are on the agenda for potential action, and we'll take those first and then take a break so that the committee report on those can be forwarded to the Secretary of the Senate. And our allotted time is quite short. We have this room for an hour. I don't believe there's a hearing scheduled beyond 11 o'clock here, so if we do keep the room, we may continue with the hearing only. I will point out that many of our members have a caucus meeting that starts at 11. All right, we'll start with Senate Bill 222. This is a bill I'm the main sponsor on. We're dealing with LC 289301S. This is a very simple bill. Primary purpose is to extend the Georgia Council on Criminal Justice Reform. The original legislation that created the council sunsetted last July. I don't think it needs much saying, but that's been a bipartisan success for the last 7 years, and we hope to continue the progress to allow the council to continue to implement the reforms that have already been passed and to evaluate their success or failure because this is a data-driven process and we want it to continue. A lot of work's been done by the council. It had been issuing reports annually. This bill only requires reports every 2 years, which was in the original language, but of the bill that passed several years ago. But because of the volume of business tackled by that council, annual reports have been the norm. I'll point out a few changes from the original legislation that created the council. We have, over the last several years, had additional agencies come into being or have weighed in heavily on the work of the council. So even though the council membership stays at 15 members, all governor appointees, the agencies represented are expanded to include Department of Corrections, the Commissioner the Department of Community Supervision, the Department of Juvenile Justice, and the Commissioner of Department of Behavioral Health and Developmental Disabilities, leaving one member undesignated by agency. Another change is the agency to which the council is attached. It had been attached to the Department of Family Affairs, I believe. Anyway, the agency to which it had been administratively attached is no longer operating. So the agency to which it was originally co-staffed, that's the Criminal Justice Coordinating Council, will serve both as an attachment for administrative purposes and to provide staff to support the work of the Criminal Justice Reform Council. The extension period in the draft of the bill, or the bill as dropped, had been for 2 years. We've extended it to expire June 30th, 2026. So we've gone a little beyond 2 years. With that, I'll be happy to answer any questions. We do not have any person signed up to speak. See no questions. I see a question. No? Okay.
The appropriate time, Mr. Chairman.
All right.
Mr. Chair would like to entertain a motion.
I would.
Thank you for your work on this, Mr. Chairman. I would make a motion to pass.
All right. Senator Parent.
Sorry. Spoke out of turn.
Second by Parent. All right. Any discussion? Hearing none, all in favor signify by saying aye. Aye. All opposed, like sign. All right. That moves us to the next item on the agenda, which is Senate Bill 167. Senator Matt Brass. Good morning.
Morning, Mr. Chairman, members of the committee.
And we're working off LC 480061.
Yes, sir.
All right, tell us about it.
Well, as y'all know, we did a hearing last week on this. Simply what this does is help with the stability of a child in foster care. We're just simply giving the foster parents a little more preference than they currently have when it comes to deciding the permanency of the child. As we all know, ultimately our goal is for a child to go back with his parents if for whatever reason the child goes into foster care, if the parents can fix those issues. But we're oftentimes finding that children that are in these foster homes are being removed from family members that are coming sometimes from out of state and sometimes distantly related, and coming down the road, maybe a year or 2 years out. So we're just simply giving the department a little bit more direction as to when they can stop the active search for family members. And essentially what it does is put a little more emphasis on the family to come forward in a timely manner, and that's it.
All right, any questions for Senator Brass? We do not have anyone signed up to speak. What's the pleasure of the committee?
Need to pass, Mr. Chairman.
By Parent. Second by Heath. Discussion. Hearing none, all in favor signify by saying aye.
Aye.
Opposed, like sign. Thank you.
Thank you, Mr. Chairman. Good luck today.
All right, the next item on the agenda is Senate Bill 229. Senator Robertson. Good morning.
Good morning, Mr. Chairman.
You're getting a lot of bills this session.
Yes, sir, I'm afraid they're coming due.
Go ahead.
Mr. Chairman, I'm here to speak on the parental accountability courts legislation that has come out of the Office of Health and Human Services. I believe you have a new LC number in the amended legislation that should have been transported over this morning.
That's 480099S. Is that right?
That's correct.
That's correct, sir.
Go ahead.
Yes, sir. Currently, 45 of the judicial circuits within the state of Georgia, of the 49, currently have parental accountability courts. The primary purpose of these parental accountability courts is to help stem the incarceration of chronically delinquent payers of child support. What the court's main goal is to take these individuals who either through economics or other reasons can't pay their child support, and to offer resources within the community to help solve that problem, so that we're not incarcerating individuals who certainly are not going to be able to generate any type of income while incarcerated. These courts have been around for a while. They've served over 7,000 Georgia parents, over 10,000 children, and have brought in $7.5 million in child support payments. What this legislation would do, and basically most of the courts are already doing it, so we're trying to codify it in law. The proposal seeks to amend the definition of accountability courts to include the parental accountability courts, and to create the authority for the implementation of the courts with the same and similar provisions of other accountability courts throughout the state, so that we have seamless operations in all 159 counties. The proposal seeks to amend the definition of accountability courts found in OCGA 15-1-18 to include parental accountability courts, also referred to as PACs, the good kind of PACs. The legislation will also create a new statute addressing the purpose, authority to implement, and the funding sources of the parental accountability courts. It'll add the courts to the description of court divisions, which automatically triggers and practices, which ensure that the accountability courts will be following those standardized practices that we were just talking about, and align with DCSS expectations and program goals.
And it's clear that a judge of a parental accountability court will not be authorized to modify or reduce or increase support obligations.
That's correct.
Since they've been rolled
I
out,
think so. And also, you know, a side advantage to it is the individuals that are incarcerated for not paying child support come into the system without a bond, because it is a civil action until they can appear before the judge assigned to that particular case, and many times that particular domestic case. And so, but I think the biggest advantage to it is the fact that it standardizes the practice and codifies it in law.
what are the changes? Can you point to changes?
So, if I could get, I'm sorry, I believe there was an oversight in not adding 15.6.29, which I'm sorry, and that's line number 141, which authorizes the supplement.
All right.
And I have my child support attorney here with me that can identify the other section that was overlooked. Oh, I'm sorry, he didn't make it in. There was one other section that I think that Ledge Counsel had omitted. And if you would give me a second, I thought he was behind me.
He's in now. He's behind it.
Okay. Yeah. So the other oversight on the code section that wasn't previously identified was,
What line is it?
That's 132, 136, 15, and 118.
right,
what
that's line number 132 in section 2.
All right.
They're already aware of that.
All right, that's it.
That's it.
Any questions for Senator?
Ending total dollars of outstanding child support currently owed. And
No, I would have to follow up with you on that. Are you speaking specifically to those that are involved in this court?
no, I'm speaking just generally as the state as a whole, because that would obviously help make the case for why such a court might be necessary.
I have my division director here as well, and she may be able to speak to that.
I would dare to say it's much greater than the 7.65 that has already been collected through the accountability courts.
Right.
So this
Senator
is
Tillery.
the State Division of Child Support Services Director, Tangela Gray, and she could share.
I wanted to thank you for the opportunity to address your question. We are collecting a little more than $740 million in child support on average a year. Without this type of support, we lose almost $1 billion in current support and arrearages that are owed to the children families.
Wow. That's a great question. Thank you. I may follow up with you
Go ahead.
offline with other questions. Thank you
All
for
right.
your candor.
All right. Any other questions? Well, I certainly applaud the efforts of the agency. It doesn't help feed hungry children by putting delinquent
Absolutely
parents in
correct.
jail. This costs taxpayers money. You're saving money for the state and providing support for the children.
Yes, sir.
Thank you very much.
Thank you.
Anybody signed up to speak? And I do not see anyone. Any other questions from the committee? Do not see any. What's the pleasure of the committee?
Move to pass.
By Tillery? Strickland? They sound like Tillery today. All right, did you get that?
Yes, I can.
All right. Any discussion? Hearing none, all in favor signify by saying aye.
Aye.
Opposed, like sign. Thank you.
Thank you, Mr. Chairman.
Thank you, Mr.
Any
Chairman.
other
Thank you,
public
committee.
That brings us to the next item on the agenda, Senate Bill 58, Senator Karen Shack. We're working off of LC 41-1927S.
That's correct, Mr. Chairman.
All right, anytime you're ready.
Thank you, Mr. Chairman, and thank you to my esteemed colleagues on the Judiciary Committee and also to my fellow Georgians here with us today. I bring for your consideration Senate Bill 58, which is an amendment to the Georgia Taxpayer Protection Against False Claims Act, which was passed by the legislature in 2012. A similar law currently exists in 29 other states. This law has served as a critical tool for law enforcement to protect our taxpayer dollars, but it needs a little tweaking, and that's why we're here today. We are only seeking to delete 7 words from the current statute, which is upon written approval by the Attorney General. Under the current statute, a whistleblower must get the express permission of the Attorney General to file his or her claim. No other state requires this step. This is extra red tape that really has no value because the Attorney General has the ultimate right at all times to dismiss the action at any point after its filing.
And
Why?
You made that clear by going back to that civil action may be dismissed language.
That's right, sir.
All right, good.
Now, you may ask, why is this a problem? Well, in whistleblower cases, there is a first-to-file rule, and that is whoever files first wins. Late whistleblowers don't recover, or they get much less. So it's important to get to the courthouse first. This gatekeeping role is unnecessary because, as we've said, the Attorney General by statute has power to dismiss the whistleblower's claim if he thinks it's without merit, and he also has the opportunity to intervene at any time during the action The law as written places an undue burden on the Attorney General by tasking him to decide whether to approve a case very quickly and without all the facts, in essence trying to make this decision very quickly in a vacuum. Whereas if they were not required, he can evaluate the case more fully after it's filed.
And as you indicated earlier, at the earlier hearing, this will resolve potential statute of limitations problems. I have a question. You have deleted an entire section that dealt with 49-4-168.2. That was limited to Medicaid claims.
That's correct, Mr. Chairman. As you recall, that was a change to some serving of documents, which on further reflection did not think was necessary. The critical point for this legislation is the deletion of the 7 words. And so I went back to just that change and presented that today as a substitute.
Under Title 49 actions, that prior approval was not in the statute?
That is correct, Mr. Chairman. It is not required in the Medicaid statutes, nor is it required in any other state or the federal government. And so this would really put us in the same position as other states, and thus we would not be disadvantaged by whistleblowers going to other states because they have a better chance in those states of getting their cases heard. I did want to introduce, Mr. Chairman, with your deference this morning, that I have Mr. Michael Sullivan here with me today. He's a former federal prosecutor who has more than 30 years of experience in sophisticated civil and criminal litigation. He has worked with the False Claims Act since the late 1980s and has both defended and prosecuted cases under the False Claims Act. And most importantly, he worked on the prior legislation, both the Medicaid statute and this statute, with the legislature, with Representative Lindsay, and also with the Attorney General's office back then. And I'm happy to have him here today with me to address your questions and speak as well.
Before you hand it off,
Yes, sir.
the actions under Title 23, are they limited to false taxpayer claims, or do they apply to other whistleblowing cases as well?
The whistleblower statute allows anything other than the Medicaid, and the Medicaid is under Title 43.
So it's a little broader than the title suggests.
Yes, sir. It allows everything other than the Medicaid, which is specifically in the other statute.
All right. Mr. Sullivan, if you could briefly give us some helpful information.
Thank you, Mr. Chairman, and thank the members of the committee. I'm Michael Sullivan. I practice law in Atlanta with a firm called Finch McCraney, and I have worked with the False Claims Act, the Federal False Claims Act, since the late 1980s. I'm going to give you a little bit of background that hopefully will make this amendment make sense. This is the Federal False Claims Act was enacted under President Ronald Reagan at the instance of Senator Chuck Grassley, largely, to stop the theft of taxpayer funds, or at least to deter it. There's a lot of people, as we all know, who prey on opportunities to steal money from government programs and government spending. In around 2005, Congress sought to encourage states to pass their own False Claims Acts. Georgia passed the Medicaid False Claims Act, State False Medicaid Claims Act, in 2007. And Representative Edward Lindsay was a co-sponsor of that, had asked me to participate in the drafting and then come down here like I'm doing today to explain it and answer any questions about it. And it's worked extremely well. The Attorney General has cases filed where people say some Medicaid dollars are being stolen, and the Attorney General looks at it. If the Attorney General thinks it's not a meritorious case, he can call the lawyer up the next day and say, you need to dismiss the case or I'm going to do it. And that's what usually happens for non-meritorious cases. So move forward a number of years to leading up to the 2012 session, Representative Lindsay asked me would I help draft a similar False Claims Act to protect all other state and local government spending. And I was happy to do it. This became the bill we're talking, or the law we're talking about today, the Taxpayer Protection False Claims Act. And late in the process, there was an extra step put in that would not only give the Attorney General ultimate authority to dismiss the case once it's filed, but also burden the Attorney General's office with having to do a pre-filing approval. And as Mr. Chairman pointed out, that creates a problem with the statute of limitations, because some of the state or local government money that's been stolen might never be recovered if that statute of limitations date does not run fairly promptly with the presentation of the claim. That provision has had some other unforeseen negative consequences. It has deterred the filing of good cases because it's sort of a process that takes place in a vacuum, and what we've seen, and I've kept up with the Attorney General's office informally over the years. Just as an aside, once this was passed, they asked me to help coordinate a group of defense lawyers and plaintiffs' lawyers to come up with some procedures for the AG's office to use to screen these cases, which we did. But it seems like it's been a headache and an unnecessary impediment, and really has accomplished nothing good, given that the Attorney General's office can dismiss the case the day after it's filed if it's not meritorious anyway.
I don't mean to cut you short,
Yeah,
but
that's pretty much.
the Attorney General's office has not weighed in opposing this.
That is correct, Mr. Chairman. They are monitoring, and I have informed them during all steps, and then they also know about the hearing this morning.
All right, thank you. Are there any questions for Senator Karenchak or Mr. Sullivan? Senator Cowser?
Thank you, Mr. Chairman. So on the Medicaid Fraud Claims Act, does that currently require the Attorney General to sort of give his pre-clearance?
No. And the system has worked fine since '07. There's no pre-clearance because, as I said, if he doesn't think the case has merit, he can dismiss it fairly promptly after it's filed. And that's true. I think there's about 30 states who have these laws, and none of the other states require this pre-approval. It's just an extra step of red tape.
One further question,
Go
please,
ahead.
Mr. Chairman. When I first read the caption of this, it makes it read like taxpayer fraud, almost like you're claiming I didn't pay my taxes or not paying them fully or whatever. Does this go anywhere there, or is it just misusing taxpayer funds, state funds?
Misusing taxpayer funds. It's really to protect, nobody wants to pay high taxes. And if we can deter people from stealing taxpayer dollars, this money from the state and local governments, then we're all better off. So I think that's why that's what that title means.
More of just an anti-fraud statute defrauding the public treasury?
Yes, sir.
Okay.
All right. Any other questions? We don't have anyone else signed up to speak. What's the pleasure of the committee?
Make a motion to pass this.
Parent? Oh, I'm sorry. Senator Heath? Didn't
Sorry,
mean to
Mr.
cut you short. Go ahead.
Chairman, I was a little bit slow getting on my button there. Does this in any way put taxpayers' information that would have otherwise been considered confidential, does it break that confidentiality? I know it's sort of an issue we deal with a lot in the Finance Committee, trying to protect taxpayers' private information, but would this put that at risk?
Not at all. And actually, the statute says this does not apply to people's taxes that they pay to the state. So none of these cases deal with somebody's tax return information. They're all about, let's say if somebody was defrauding the dredging project for the Savannah River or, MARTA funds or what have you. It really has nothing to do with taxpayer information, so it doesn't put any of that at risk of disclosure.
And if I might add to that, any person's personal information is redacted. So anybody who would be litigating these types of cases would be protecting any kind of personal information as required by law already. So this would not impact that duty in any way.
May I
Go
forward.
ahead.
So would it allow an attorney to subpoena information, or in the findings part, to request information relative to tax filings that would not otherwise exist?
No. Taxpayer information is again carved out of this statute and this whole statutory scheme. There's a federal IRS whistleblower program. Most of the states don't have one, but this is entirely a different animal.
Thank you.
So this would not extend to cover reporting someone for claiming too many deductions.
Correct. Would not extend to that.
Okay.
Yeah.
All right. Any other questions? Hearing none, what's the pleasure of the committee?
Mr. Chairman, I'll renew my motion.
All right, by Parent. Second by Jones. Any discussion? Hearing none, all in favor signify by saying aye.
Aye.
Opposed, like sign. Thank you.
Thank you. Thank you very much for your time this morning.
Thank you.
That brings us to the next item on the agenda. Senate Bill 150, Senator Jordan, you have. I believe we're working off of LC 289282ER. And this is an additional.
Yes.
And then we also have in our folders a proposed amendment to the latest LC.
Correct.
While you're getting ready, what this bill in its current form is intending to do is to true up the Georgia law with federal law restricting gun ownership in cases of domestic violence. Is that a fair statement?
That's correct. And the
Go
bill.
ahead. I don't mean to steal your thunder.
No. I mean, you said exactly what I was going to say. It's really just to bring federal law and state law into alignment. And it is here really because of a law enforcement initiative by folks across the state who prosecute these cases and who also see kind of the harm with respect to law enforcement in terms of domestic violence cases. And while I'm happy to speak to it, I think probably more significantly for the committee, it's important to hear from prosecutors who deal with these issues every day. And I have with me Sherry Boston, who is the DeKalb County District Attorney, and also Stephanie Woodard, who is the Solicitor General for Hall County. And so I'm going to turn it over to them because really they know kind of what's going on with respect to these cases and why this alignment is needed.
I ask you to keep your remarks brief, couple of minutes if possible.
Yes, Senator Stone.
Go ahead.
I also want to acknowledge that we have the district attorney from the Cordeal Circuit, Bragg Rigby, is here. And let me state that Ms. Woodward and I are here on behalf of all prosecutors in the state of Georgia. We have been authorized to lay support on this bill from every DA in the state of Georgia, as well as every elected Solicitor General. And we have the full support of the Prosecuting Attorneys Council. So this truly is a law enforcement safety initiative with the effect of protecting our victims of domestic violence. The only thing we want to do with this bill is to mirror what is already federal law. It is against the law of the United States to possess a firearm if you've been convicted of family violence battery. Locally on the ground, we really have no way to enforce this particular law. It can only be enforced by federal prosecutors who, as you know, are very busy and don't really have the ability to see what we see on the ground locally in Georgia, which is trying to remove firearms out of the hands of proven and convicted violent offenders. And primarily, our concern is twofold. First, we know that law enforcement officers, that these are the most dangerous calls. And we have some law enforcement officers here present with us today. I'd ask them just to stand, that are here in favor of this bill, and also making sure that we protect our law enforcement officers on the road. We've been acting in collaboration with them to deal with these issues. Second and foremost, we want to protect our domestic violence victims. Because they are at risk every day at the hands of domestic violence offenders who have access to firearms. And I have to my left two of our very active and prolific supporters who have been victims but are survivors and are using their voice to talk about what they faced at the hands of their domestic violence abusers and what could have been had those offenders not had access to firearms. At this time, I'm going to turn it over to my partner in prosecution, Stephanie Woodard.
I think what I'd like for you most to hear, ladies and gentlemen, is this is bipartisan public safety initiative. This is about keeping people alive. We know in intimate partner violent relationships, especially in the leaving or in the court intervention during criminal proceedings, that is the highest lethality for the alleged offender, for the victim, for the neighbors, for the law enforcement. In fact, in the Commission on Family Violence, for which I'm the board chair of the state, we see that nationally, even our mass shooters have a high probability of involvement with domestic violence in their home, if not in their upbringing, in a situation at that time. We're asking, law enforcement is asking, the colonel from DNR yielded his seat to other people here. The Sheriff's Association is represented by Sheriff Johnson. I think he's in the hallway, unable to get in as well. Chiefs, sheriffs, DNR are asking for the ability to diffuse and take charge of those situations. We're asking that it simply mirror, that we not do anything. We have developed a information packet at www.safergeorgia.com that you can see a lot of our statistics, and we filled your inboxes with 10 years worth of data from Georgia. This is about keeping all Georgians, everyone involved in those situations, and the people surrounding them safe.
All right. We have a question from Senator Tillery, excuse me.
Thank you, Mr. Chairman. Thank you for bringing this bill, and thank y'all for being here, too. I know that takes a lot for you. I appreciate what you said, and I'm generally in support of the bill. Your comments about the intimate partner relationships, that I see where you're going with that bill, and I wonder if we don't go a little bit wider than that, and it's in line 18 of the amended bill. When you're talking about the folks who would be included in this, foster children, other parents, step parents, et cetera, and then it goes persons living or formerly living in the same household. There's no time restriction around that, and there's also no limit rather than just formerly living. And what my concern is that we're throwing a really big net out there that would even catch folks who happen to live together and as college roommates that now 20 years down the road would be subject to this. And I've got a proposed solution for that I'd hope you'd entertain. But first, I'd love to hear your comments as to that.
Well, first, let me state, I absolutely recognize your concern, Senator Tillery, because we don't have a definition of intimate partner violence anywhere in the Georgia Code. We refer to it as a family violence battery statute, and this is the definition used throughout. So currently, as it stands, even when we're prosecuting a family violence battery, this is the definition here in Georgia. So I would first state, we need to make sure that we don't create a circumstance where we would have two potential different definitions when it comes to family violence battery. Additionally, keep in mind that as prosecutors, it's our responsibility to prosecute these crimes. And generally speaking, you're going to have a prosecutor that would not lump let's say a college roommate, two roommates at, say, the University of Georgia, that would not typically be prosecuted as a family violence battery for purposes of a criminal conviction So we wouldn't even get to the point where that would fall into this definition for purposes of losing your right to a firearm.
And Senator Tillery, I will also say this is the language in the federal code.
Go ahead.
I was wondering if you would entertain this potential amendment in line 18. In line 18, if you go after the word household and put as intimate partners, which seems to be exactly what you're trying to address. So then it's people who have lived or living or formerly living in the same household as intimate partners. And then I realized we'd have to define that, and I've got a definition if you want to take your hand at that one too. You'd then probably end up dropping somewhere after the conclusion of number 2 and adding a number 3. Looks like we'd probably be on line 29, before line 29. And define intimate partners and say intimate partners means individuals who have lived in the same household and had a sexual relationship without being married. That way we don't end up getting into the problem of step parents, etc.
And I believe this would follow the, this qualifies the broad or other persons language.
Yes, sir. It
So
would.
it doesn't take away from any of the previous.
No, sir. It would only follow after the comma in line 18.
All right.
If I may, the only, as we're talking through this issue, we are now would be excluding family violence that happens among family members living in the same household that would not be intimate partners, perhaps a father-son, a mother-daughter, a brother-brother.
Is that not covered in line 17 when it says child?
Unrelated.
I support your idea.
Absolutely.
I'm just trying to make sure that we get to the net that we're really trying to cast.
And we absolutely appreciate that. Again, I would just note that this would be the only section that would have this definition of intimate partner violence. So the statute that defines family violence for other purposes of either criminal or civil litigation would not have this distinction in regards to intimate partner violence, because this would be the only place in Georgia code where we would have this specific delineation. So that would be our major concern, is that we're carving out an exception in one place, but in other places where we reference family violence battery, it goes back to, or the definition of family violence offense, it would go back to subsection A1.
And if I may, respectfully, adding an element of we have to prove that they've had sex, which is an incredibly personal issue into a highly volatile, but it's an evidentiary proof item that we would then have to.
Well, that's my suggestion is how to handle it. How do you help? Can you give me better language that helps address the issue of the very wide net that we've cast?
So, if I may, the way that it's defined under federal law, under the section that we've taken all the other language from,
You don't have the USC site, do you?
I do, actually.
I believe it's 18 USC 391.
They're 18 USC 922, and want to make sure I've got the definitions section too. Let's see what I've got. Yeah, that's. So the particular code section is 18 USC 922, and then 921 has a lot of the terms that are defined. But to move it along, and I'll make sure I get you the specific section, but the way that it's defined under the federal code section that we've been tracking to make sure we're going no broader. The term intimate partner means with respect to a person, the spouse of the person, a former spouse of the person, an individual who is a parent of a child of the person, and an individual who cohabitates or has cohabitated with the person.
And that's a definition in the federal law?
In the federal law.
And in my conversations with the NRA and their national states council who have been in support of this, they've asked that we follow the federal specifically in the definition of relationships.
And that is 18 U.S.C. Section 921.
Is there a subsection?
I think it's 32. It's all the way at the bottom.
All right. Senator Jones?
Yes, sir, Mr. Chairman. I was just also going to reiterate to Senator Tillery that this also would follow the language that's in there today. Also follows the language that you have for family violence battery, simple battery, that's already in the code. And I certainly understand your concern about it, but I would say, as someone who's prosecuted for 12 years, that you just it is a concern, but from a practical standpoint, this is the best language to use. And then number two, if we change this language in here, it is going to cause a major issue as far as prosecuting battery cases and things of that nature, because you now have two different definitions of it. But this is the exact same language that's been used. So we really started prosecuting the family violence battery and simple battery statutes in Georgia.
Senator Tillery?
Thank you, Mr. Chairman. I do respect Senator Jones, and I appreciate your prosecutorial background. I simply disagree with it from a fact of you still can prosecute that crime, and it was something I definitely would want to do. But this goes to that second point of now we're going to remove a constitutional right, and I want to make sure that we've tailored it to as the way we intended to tailor it when removing that.
And also
sorry.
with respect, just to respond, that's why we've really hewed so closely to the federal law, which does exactly what we're asking, which is for misdemeanor convictions of domestic abuse, we want to make sure it's as narrowly tailored as possible, and that's why we, to a T, covered in terms of tracking the language with the federal and state law, not to go any further, so that we could address anyone's concerns in terms of overreach, because we know that we don't want to do that.
And respectfully, the commission's asked, and I believe will be engaging in an after session over the summer break study committee, looking to define family violence more in step with our modern understanding of families and intimate partnership, and address the entire code at once. But I'd ask you not to let perfection stop progress. This tracks federal. This is about keeping people alive, and let us deal with that holistically at the actual, in a uniform way across all of the codes that deal with family violence.
Just to make sure there aren't any unintended consequences by adding that language, and especially since it goes even further than necessarily, or it is different than the federal language that everyone has kind of signed off on in terms of the stakeholders that have been.
Right, but I think that's exactly where I'm going, is I think this does have unintended consequences of going further than you wanted to. But I understand that sometimes people disagree with me.
All right. Any other comments or questions? We have some others. Okay. Senator Heath.
Thank you, Mr. Chairman. I just trying to kind of follow through with what seems to be the process in the committee, and I'm not totally following how the proposed amendment would fit into the bill that we have before us. But if you would look at lines 72 and 73, I think that is the bottom of the proposed amendment that was handed out. But at the proper time, I would like to discuss or make a motion to strike the words on line 72, suffering from a disability pursuant to this code section, so that it would read, any person may seek to have his or her rights restored by the State Board of Pardons and Paroles after 5 years has passed, etc. I think that is an intent or something we've discussed before in the General Assembly, and I think we could accomplish what the author is seeking to accomplish without just narrowing it down to persons with a disability. And I will point out that some disabilities are as simple as a hearing loss.
All right, Senator Parent.
I might be wrong about this. Hopefully our witnesses can weigh in, but Senator Heath, I believe disability in this context means your disability is that you've been excluded from weapons possession pursuant to your conviction. And for example, if you've been in another context, which we've also discussed, involuntarily committed to a mental institution for being a danger to yourself or others, you would also refer to that as a disability under the criminal code with weapons restriction. It is not your standard disability with eyesight, developmental disabilities, hearing, or anything else. It's a specific disability arising from your conviction. A legal disability, if you will, yeah.
The intent of this language.
I don't think so, but I'm gonna.
We're checking on that. While we're doing that, I'll go ahead and explain the amendment. The amendment was further reflection by some of our gun rights organizations to define antique firearm and also to widen the forums in which petitions to restore rights can be brought to Superior Court or State Board of Pardons and Paroles. Do you have an answer for it?
Yeah, yes. The only disabilities that are being referenced in 1611 131 is the inability to carry a firearm due to the fact that you've been convicted of a felony. So that's the only disabilities that's being covered in that code section.
Where, do you have the site on that?
That's right here.
Okay. All right. Okay. All right. Any other questions or comments?
And just so y'all know, in terms of the antique firearm, that is taken verbatim from the federal code as well. Just one comment on the restoration of rights language, which I know some groups have requested, and I understand that some other groups have indicated that it may, the only issue is that at the federal level, there is not a restoration of rights. And so we just, the only concern is that if I am a Georgia gun owner and I go through the restoration of rights process at the state level and get them back, that I may rely on that and think that I can have a firearm at the federal level, and the federal level would not recognize those restoration of rights. So that's my only, I just wanted to bring that to y'all's attention, but that's it.
Thank you. Any other questions or comments? All right, well, we're going to try to run through these persons that have been signed up to speak very quickly. If you'll limit your comments to a minute and not repeat what someone else has already said. I'm going to call on April Ross. Are you here?
Yes, right here. Respectfully, sir, may both ladies come up together?
Yes. And I believe Janet Paulson. Okay. Anytime you're ready, you can start.
Thank you to the committee for allowing us an opportunity to speak. My name is April Ross. I am a survivor of domestic violence, approaching 5 years from my injury. I'll just add that to me, this is highly important because being on the receiving end of someone pointing a gun and firing at you changes so much of your life. And I'm grateful that I'm still here. My family is grateful that I'm still here and not a picture on their fireplace mantle. But there are so many who aren't here because an intimate partner decided you can't leave or you're out of line, and it pulled a firearm on their spouse or lover. I just want to save lives. I just want people to not go through what I went through or families be affected. In my case, the damage to this is so much greater than the individual. It casts such a broad net to your families. And in my instance, my abuser also took his own life and shot the passenger in my car. So you have 3 families and all of those collateral relationships that were severely affected by someone who had the opportunity to take a gun and decided to use it against an intimate partner. If there's any chance that we can reduce those people's access who are likely to take that step, I think it's worth it for any life that can be spared from either death or serious disability. And Janet and I actually met through the Shepherd Center, recovering from spinal cord injuries. I've also done peer support and met other patients similar to both of us who survived but were severely disabled as a result of firearms pulled on them by their partners.
All right, thank you very much. Janet?
Yes, my name's Janet Paulson, and I had been married for 18 years to a man that had issues with alcohol. And there were some mental health issues also. So I finally got to a point where I had to leave, and I had to take my children and leave. I have 13-year-old twin boys. Well, they were 13 at the time. And as soon as I told him I wanted a divorce, the threat started. Why don't you try and leave and see what happens to you? He called my father and told my father that he was going to kill me if I thought I was going to divorce him. He called my neighbors, started telling my neighbors the same thing. It was so scary that the boys and I didn't come home one day. We were living in a hotel. He was also a firearms enthusiast. There were 74 firearms in my home. And when I went to court, like the police told me to do, and my attorney advised me to do, I brought pictures of all the firearms that were in my house. I asked that they would be confiscated, but they let him leave with the handgun in his truck that I had written on a list and that my local police department told that he had. 5 nights later, he ambushed me and he shot me 6 times with a 9mm at close range. He shattered my right femur, he shattered my left knee. I have a through and through in my thigh next to a main artery. I have a through and through from my back out through my stomach, close to my heart. I have another shot that took out a third of my right lung. And then the last shot, as I was laying in my driveway bleeding to death and he walked over 2 feet from me, hit my L2 vertebrae. So I was paralyzed from the waist down. I almost didn't make it to the hospital. When they got me there, they had to crack my chest because my heart had stopped beating. That means they spread my chest, they took electrodes, shocked my heart, and the trauma surgeon massaged it with his hand and it started back. I was told later that that only works 1 out of 100 times that they try and save someone that way. In between 2010 and 2018, there were 850 Georgians killed in domestic violence shootings. That's just shootings. And 20% of those people were not the victim or the perpetrator. They're the children of the victim. They're the other family members that were in the way. See, I got lucky that night. It was just me. He was waiting on myself, my children, and my dad. We were at football practice. But I happened to have groceries in the car, and I came home early. So I was the only one that he got. Most women don't make it. So I feel a responsibility to speak for those women and the ones coming behind April and I, so they don't have to come up here and do the same thing.
Thank you very much. We have several law enforcement prosecutors, I believe. If you'll just stand and state your name and your position on the bill. Jennifer Handel.
It's Jennifer Wakel, sir.
I'm sorry. Okay.
Shall I speak now?
Yes.
I'm an investigator currently with the DeKalb County District Attorney's Office. And prior to that, I worked 12 years in probation through the State Court of DeKalb County. So I have a unique perspective of pre and post conviction. And when I supervised the domestic violence unit, there were 4 of us that were domestic violence probation officers that only monitored domestic violence cases. And we would see time and time again, and it was about 950 a year, give or take. And we'd see time and time again people violate their probations, usually involving new cases involving a firearm, whether that's an armed robbery of a stranger, aggravated assault of an intimate partner or a family member that's not an intimate partner, some manner of the public, or aggravated assault attempt on a police officer. And so when we do our paperwork and we take our warrants to the judge and we get them to the probation revocation hearings, the one thing we can't hold them accountable for is having that domestic violence conviction and not being allowed to own or possess that firearm under federal law. Because as a state peace officer and as state court judges for the state of Georgia, we don't have the authority to enforce federal law on a state level. So that handicaps us in one way of holding that offender accountable. What I saw as I transitioned into the district attorney's office a couple years ago is the case packets that I look through and investigate daily. There are many prohibited parties also with prior domestic violence convictions having new incidents involving firearms. Same things I mentioned. Armed robberies, aggravated assaults, possession of a stolen pistol, and so forth. But as a state peace officer or as the district attorney or the line police officer that makes the initial arrest or deputy, we don't have a mechanism to charge the same as possession of a firearm by convicted felon as someone is possession of a firearm by a prohibited person under domestic violence conviction. And I feel if we had that, that would keep many law enforcement lives safer and also the civilians of the whole state of Georgia.
All right. Brad Rigby.
Hi, Brad Rigby, District Attorney at the Cordial Judicial Circuit. I don't have anything additional to say other than what's been said. We support the legislation.
All right. Jay Eisner.
Thank you, Chairman. Members of the committee. I'm live in Loganville, but I've been a DeKalb County police officer since 1992, and I'm currently commander of our Special Victims Section, and also train across state on this. So I know you already know that this isn't taking any rights away if you haven't already been convicted of a crime, which I think is important. It just gives us the ability to enforce the laws that are already there. Under federal law, the people convicted of these domestic violence misdemeanors are already forbidden from having the guns, but as a police officer, it's very difficult to enforce that out on the road, in the field, because we don't have that mechanism under state law. One thing I would mention as a trainer is I'm concerned about if we don't continue to mirror the current state law and federal law, it makes us, sets us up for some liability with a special section, because it's going to be hard after 30 years we've been training that this is the family violence law definition in Georgia. I am a big fan of the idea of holistically looking at the entire code section, in a way that we really make sure we make any changes in a prudent manner. And then finally, as an officer safety instructor, it's a very dangerous situation. You go into a situation where that person probably knows they're not supposed to have the gun,
Last one.
but I don't have the legal authority to take it. That I believe the gun with them because it's federal law. I can't seize that contraband because it's not contraband under state law. So this makes it safer for us when we're out there in the moment. It's just giving us the ability to enforce that law that's already there. So I thank you very much, sir.
Thank you. All right. No one else signed up to speak. What's the pleasure of the committee?
Move to pass.
Second.
All right. Motion by Strickland, second by Parent.
Kennedy.
Or Kennedy. Sound like. All right. Any discussion? Senator Tillery?
Mr. Chairman, I do want to make a motion that amend
Yes.
at the right time.
Go
Amend
ahead.
after line 18, add as intimate partners.
Add the words "as intimate partners."
And add a new definition for intimate partner.
And can you state that definition slowly?
Yes, sir. Intimate partners means individuals who have lived in the same household and had a sexual relationship without being married.
Do you have that? All right. Is that your entire amendment?
Yes, sir.
Is there a second?
Second.
Second by Cowser. All right. Senator Heath? I'm sorry.
Did you want to, I'm not challenging your expertise in chairing the committee. Did you want to handle that one and then do a separate one, or you want to roll them
I didn't know
together?
if you were lit up to comment
I wanted to
on
make an
that.
amendment as well.
All
Or
right.
offer an
Well,
amendment.
let's deal with the First Amendment. All right. Any further discussion on Senator Tillery's amendment? Hearing none, all in favor signify by saying aye.
Aye.
Opposed, like sign.
No.
All right, let's take a hand count. All in favor of the amendment, raise your hands and keep them up, because my secretary just stepped out. All opposed? Oh, keep them high. Is that 5-4? 5-4 against. Okay, the amendment fails. All right, Senator Heath.
Yes, sir, Mr. Chairman. I would move to amend the bill. I think we're working on the LC 289282 ER.
Yes.
So on line 72, beginning at the word suffering from a disability pursuant to this code section, strike those 9 words so that it reads, any person may seek to have his or her rights restored, etc.
All right, is there a second? Going once? All right, it fails to have a second. Any other discussion on the bill? All right, we need an amendment to add section 5. If someone would. All right. Senator Ligon.
Second.
Tillery, second. Any discussion? Hearing none, all in favor signify by saying aye. Aye. All opposed, like sign. All right, now that brings us back to the main question. Is there a motion to adopt the substitute as amended?
So moved. Second.
All right, motion by Strickland, second by Parent. Any discussion? Hearing none, all in favor signify by saying aye.
Aye.
All opposed, like sign. Just a moment. All right, that concludes that item on the agenda. That brings us to Senate Bill 164. And before you start presenting, Senator Cowser, give us a moment. All right, go ahead. Anytime you're ready.
Ready. Thank you, Mr. Chairman. This is a bill to revise some of our procedures for pretrial release of people accused of crimes. We very largely rely on bonds in order to ensure the appearance of people accused of crimes at their court appearances. Three kind of bonds that we routinely see, and it's just security being posted to make certain, to guarantee that the person will show up in court. If they fail to show up, then they can forfeit that security, so that's the leverage to make them appear. One is cash bond, which any accused person can simply put up the amount of cash. Second is property bond, and third is commercial bond. Those are commonly utilized and were before criminal justice reform and still are. There's one other type of arrangement that can be used that we refer to as an OR bond. OR stands for your own recognizance. There's actually no security put up in that, so using the term bond is a little bit nebulous there, I think, but it's essentially somebody giving you their word that they'll show up in court. That's typically used in less serious offenses. People have a right to have a bond set because you can't presume that they're guilty. They're presumed innocent till they can have a trial, but there's a reasonable amount to assure that they will show up in court for their trial or other court appearances. Ordinarily, a judge will hold a hearing and determine what's the appropriate amount of bond to guarantee that a person will appear. We also have a provision in our law that allows judges to post schedules by an order. They can go ahead and set their standard bonds for a variety of offenses, including felony offenses, misdemeanors, etc., so that they can expedite that process. Perhaps the person doesn't have to stay in jail overnight waiting for a judge to be there the next morning to set their bond. This does not attack the use of those schedules for any bond where a set amount is set, but it does bring those into question where they're setting own recognizant bonds by a schedule without having to appear before a judge. Before I get into the provisions there, I'd like to sort of jump ahead down to the sort of bottom of page 2, lines 57 through 60. In the event that a court has set forth a schedule of bonds or what the amounts are going to be, sort of preset them, and an individual accused of crime is unable to meet that amount, then they can have a hearing before the judge, and that would be held within 48 hours of their arrest. We don't want people sitting in jail without being able to at least plead their case to reduce a bond below what's set forth on those schedules. This is really no new concept. That provision that a person that can't meet a scheduled bond is given a hearing within 48 hours is currently in the Uniform Superior Court rules, Magistrate Court rules, and Municipal Court rules. So it is a practice that is being followed now, and it's constitutionally required, in my opinion. Anyways, this is simply codifying that. If you can't meet the scheduled bond, you get to get before a judge within 48 hours and plead your case to reduce that bond. Now, the other thing that this addresses is situations we're now seeing where there are either city ordinances or these posted bond schedules or bail schedules, we reference them, that deal with minor type offenses. And we try to make clear here, this is sort of the guts of the bill on lines 16 through 26 on the first page, and then you'll see the same language on page 3 as we're referencing. That is, under what circumstances can you let somebody out on their own recognizance without having to go before a judge? And the problem that this is attempting to address is for serious offenses. The policy reason would be you should not allow people out on their own recognizance, just their promise that they will show up to court if they're charged with a serious offense, unless a judge hears the evidence and agrees to that and issues an order doing that. So it specifically says that under these certain offenses, something involving violence or domestic violence, sexual offenses, DUI, felony offenses, you can't set up an OR bond for that just under a schedule. The judge would have to see the person accused of the crime first. So you can't have a local ordinance that mandates that somebody be released on their own recognizance before being brought before a judge or whatever type of court that magistrate that they might be in front of. And that doesn't prohibit anybody from being released on their own recognizance if it's an offense that doesn't involve violence, threatened violence, theft, domestic violence, damage to property, idling or loitering involving a sexual offense, or DUI. And Mr. Chairman, in conversations with you and prior to this meeting, I'm fine to remove theft and damage to property as being
That's on
minor
line
offenses.
23.
It's
and
on line 21 and 71.
21.
It's repeated. And it also would continue to allow OR bonds to be set in situations under county or local ordinances that do not provide for a sentence of confinement. So minor things, and that's to keep from burdening the jails with vagrants and panhandlers and people camping on public property, those type of things that do not, the ordinance does not call for jail time anyway. And I think that pretty well covers it. I know there may be a couple people signed up to speak, but I'm happy to take any questions as well.
All right. Any questions for Senator Cowsert? Senator Parent?
Thank you, Mr. Chairman. Senator Cowsert, I apologize, I missed the very beginning of your presentation, so you may have touched on this, but can you enlighten me a little bit as to how this intersects or does it with SB 407, which we did last year, which I believe dealt also with bail reform?
Just sort of closes the loophole where you're not allowed to have a pre-printed or pre-approved schedule that allows people out on their own recognizance for serious offenses.
Can you
they still have a posted schedule for any crimes, including felonies, if there is a bond required, some security to guarantee they'll appear in court.
All right.
Thank you.
I have a question for Legislative Council. I've had some discussion with members of the bench. Is there a problem with the definition of bail not making any reference to OR? I'm not sure where that is. Do you see? You don't see? Okay, that must have come out. No. Just a moment. Senator Cowsert, can you address that?
What was the question?
My question to Legislative Council was the change of the definition of the term bail to eliminate any OR.
I can. As I was trying to explain earlier, to call it on recognizance bond is really a misnomer because no security is being posted. They're simply giving their word, I'll show up. So to call that bail is contradictory because no security is being put up to guarantee their appearance, and that's why that is being removed.
I know in rural areas sometimes a defendant is released to a third party's responsibility. Is that covered?
It is covered, and in this bill, if you look on pages 2, lines 50, I might be in the wrong place. Hold on. No, on page 2, line 31, it's the bond is approved. The property bond is approved by the sheriff, and again down there on 60, the security accepted by the sheriff, the amount, and then the kind of catch-all I think you're looking for is on line 75 on page 3. Nothing in this code section shall prohibit a duly elected sheriff from releasing an accused from custody by means of exercising his or her discretion. some of us when we were younger, or some of our children might have gotten that phone call from the sheriff saying, I got your child, that they've done something, I'm going to release them to your custody until we can, formally charge them or set a bond or whatever. This retains that discretion with the sheriff.
All right.
What I was going to add, Mr. Chairman, was on nothing prevents the judge from granting an OR bond or letting somebody out on their own recognizance even on these serious offenses, if they first have a hearing and listen to the circumstances, because there are circumstances where that is, a longstanding member of the community, there's no flight risk or whatever, those type of things. It could be appropriate. And the final area for that is on lines 77 to 84 on the very last page, on page 3, is if a person had been out on their own recognizance and then fails to appear in court, and so I would imagine a bench warrant or something would be issued for them. You can't give them another own recognizance bond without a judge giving a written order to that effect. You've probably heard some press recently about people repeatedly being released and coming back, committing new crimes, et cetera, not showing up to court, and they continue to let them out on their own recognizance when they've demonstrated that they're not good for their word that they will show up. So that is still permitted, but the judge would have to give a written order explaining why. And there are some circumstances where it certainly does make sense.
Yeah, I think we've heard in the news from some of the prosecutors like Paul Howard, DA in Fulton County. All right. Is that any other questions for Senator Cowsert? All right, we have several people signed up to speak, and I'm going to urge you to keep your remarks short, 1 or 2 minutes if possible. Robin Shahar. Yes, come on up.
Thank you senators for hearing me this morning. My name is Robin Joy Shahar. I'm a retired 25-year attorney from the City of Atlanta Law Department, and I was one of the primary authors of Atlanta's bail reform bill. I want to talk to you about what that bail reform bill did, what it applied to. It does not apply to serious crimes. It applies only to nonviolent misdemeanors. It does not apply to domestic violence. It does not apply to any crimes that may be violent. Those people must appear before a judge before being offered recognizance bond. The kind of crimes that we're talking about is the type of crime that Senator Coward, I think you were referring to, is you get that call about your child. This bill does not require everyone to see a judge before being allowed to post bond. It doesn't require your child to wait 48 hours in jail in order to see a judge to post bond. This bill says if you can afford to pay bail, you can go. So your child, Senator Cowart, your child can go. If you can't afford to pay bail, you have to wait in jail. And while you're in jail, you may lose your job. Your children who are waiting for you to come take care of them may be waiting without you coming home. Georgia law says you must release people on bond if they are charged with a nonviolent misdemeanor. This is not about public safety. This is about whether you can afford to be released, because the state law says you must release, you cannot deny these people bond. The only issue is, can you afford it or not? If you want to make people appear before a judge before having their bond set, have it apply to your children too. Don't have it only apply to poor people. Thank you.
Thank you. Matt McCord.
Good morning.
Morning.
Mr. Chairman, I'm Matt McCord. I'm the president of the Council of Municipal Court Judges. I have come this morning to tell you that our council opposes the bill. I also have authority to tell you the Council of Magistrate Courts opposes the bill. They could not be here this morning. I will keep my comments brief because so much of what I would say has been said today. I will tell you, I do think we're finally moving in a positive direction with some of the amendments. However, I served for a year on the Misdemeanor Bail Reform Committee with Justice Boggs, and I served again after that on the subcommittee on justice reform. So much of what we were doing was trying to find alternatives to cash bail and to improve Georgia's justice system. We are now a leader in justice reform nationally. My fear is that this takes us back to the position we were in when the city of Calhoun was sued in the Walker versus Calhoun case. We are endeavoring not to go there. What I will say to this committee is that once Senate Bill 407 was passed, I then promulgated an order statewide that did exactly what we're doing here. It in essence said that if somebody was held in jail for longer than 48 hours on a bail schedule in Georgia and they couldn't make bond, that they could be released on their own recognizance, except for DUI cases, battery cases, and cases that involved violence. I will also tell you that much of this is duplicative. Battery cases and violence cases are already addressed in Senate Bill 407. Felony cases, violent felony cases, you cannot be released. In fact, there's a presumption against bond in those cases. I think it intriguing that in the very end of this, there is language that says that a sheriff on his own initiative could release someone, but that's done without an individualized determination that would be had before a judge. It's no different in many ways than what is there now. I think that will conclude my remarks, sir, except just to say that so much of this is an attempt to make an end run around justice reform as was passed after a year of work on that committee. Thank you.
Thank you. Marissa Dodson.
Good afternoon. I have a handout.
Is it?
Just about. It's still morning. I'm sorry. Good morning. Good morning, Chairman and members of the committee. My name is Marissa Dodson. I'm an attorney and the Public Policy Director at the Southern Center for Human Rights. We are opposed to this bill, and we are opposed to it for many of the reasons that have already been articulated here today. First and foremost, Georgia has become known as a national leader in criminal justice reform. This is because of the great work of the Council on Criminal Justice Reform. There were years of multiple layers of vetting and study and assessment on what was going on in our criminal justice system, with a focus on holding people accountable, saving taxpayer dollars, and keeping the public safe. These provisions in this bill were not vetted or recommended by the Council on Criminal Justice Reform. In fact, in the Council's final report, what they asked the General Assembly to do was to actually consider non-monetary options for bail. Let's just be clear about what bail is. I think we dove right in. And we have to remember that these are individuals who have been charged or accused of a crime. Pretrial detention is punitive. Being in a cage, being incarcerated before you have been found guilty is a punishment. And we should not reserve this punishment only for people who cannot afford to get out of jail. This is not a public safety issue. If this was a public safety issue, we would say we would want to narrow the idea of who gets out of jail because we would be concerned about what they did. It is okay if you have money. You can go right back to your community. But if you don't have money, you have to stay in jail at the risk of losing your job, your housing, your relationships with your children. Everything that we know about pretrial detention is the outcomes are worse for people. You are more likely to be arrested. The longer you are incarcerated, you are more likely to get a jail time sentence. You are more likely to find yourself in that cycle of the criminal justice system. What we would ask you all to do is consider, and we do agree that the amendments are better than the bill was as it was originally introduced, but we would just ask you to consider the utility of cash bail generally, recognizing that we are not having a problem. The sponsor has not articulated that we are running into any issues with regards to people being charged with local ordinance violations or misdemeanors that are coming back into the public and causing compromising public safety. There is no connection to failures to appear being connected to just people being released on their own recognizance. This is a no issue. We believe that this is something that is being pushed by the bail industry because they are concerned that as the country and jurisdiction jurisdictions all across the country recognize that cash bail doesn't keep us safe, that they are concerned about their industry. So please do not fall into the trap of being concerned about Georgians in terms of public safety or taxpayer dollars, because this would actually force local jurisdictions to incarcerate folks who do not pose public safety risks and compromise constitutional rights of people who just don't have enough money to pay for their release. With that, I'll take any questions, but my remarks
There are no
concluded.
questions. Next is Sarah. Last name starts with a G.
Good morning, Sarah Garrity. Good morning, I'm Sarah Garrity. I am a managing attorney at the Southern Center for Human Rights. We represent indigent people in the criminal courts of this state, including Georgia Superior, State, Probate, and Municipal Courts. I am also counsel for Mr. Walker in the Walker versus Calhoun, City of Calhoun case to which Judge McCord referred a moment ago. Under this bill, own recognizance releases are prohibited for all misdemeanors in the state of Georgia, except for one, and a whole lot of ordinance violations until a judge specifically orders release. To the extent that this bill eliminates the discretion to give own recognizance bonds for minor misdemeanors and minor ordinance violations, Georgia would be a national outlier. I am aware of no other state in the country that does that, and there's a reason for this. If this bill passes, it's going to require great expenditure of city and county funds to lock up the poor and the destitute. Local jurisdictions should be prepared to have their jails fill up with people charged with low-level offenses like solicitation of money, drinking beer in public, stealing a can of beans from the CVS. These are all very common offenses and offenses for which people often cannot afford to pay bail. This bill is going to be burdensome to the courts. It's one thing in a jurisdiction like Atlanta that has court almost every day and usually gets people before a judge on the day after arrest, but as we all know, a lot of places do not currently operate like that. They may have court every few days, every week, even every month in a lot of places. And so the bill is going to burden the courts. The bill does say that people detained for 48 hours will be brought before a judge. It says nothing about what should happen when the person comes before a judge. To meet the barest constitutional threshold, the hearing would have to include an inquiry into the person's ability to pay that bail amount and a finding that the person can pay the bail amount. The bill is silent on both counts, and thus I think it probably would be unconstitutional. As for public safety, this bill lets a person charged with a felony offense out of jail any day of the week, so long as he has the money to pay. It's only if the person cannot afford to pay that he's stuck in jail. Additionally, provisions of existing law address the sponsor's concerns. The current bail statute 1761 has a list of serious offenses that are only bailable before a Superior Court judge. You cannot get out of jail under existing law before seeing a judge for offenses like armed robbery, rape, murder, home invasion, and all kinds of other offenses. Current law disallows own recognizance release in family violence cases. This is a bail industry bill. A similar bill came before the House last week. Its sponsor brought witnesses, including 4 people from the bail bonds industry. And in closing, I'd just say that we hope that the committee will think about the wonderful and much-needed reforms to bail and the criminal justice process that the governor implemented in the last several years. And I appreciate the committee's attention. Thank you.
Thank you. Next, Russell Gabriel. And Jill Travis.
Yes. Good morning, Mr. Chairman, members of the committee. I'm Jill Travis. I'm working with the Georgia Association of Criminal Defense Lawyers, and we echo all of the concerns that have been expressed by the individuals that have come to speak before us. I've brought with me today Russell Gabriel, and I'm going to let him introduce himself to the committee and give you some more information as to why we are opposed and ask you to move slowly on this bill.
Thank you. My name is Russell Gabriel. I'm currently the director of a criminal defense practicum at the University of Georgia School of Law. I'm on the faculty there. I work with law students who intern with the Public Defender Office in Athens, and prior to that time, I was the director of the Public Defender Office in Athens. I'm privileged to be before you, Mr. Chairman, members of the committee, and also Senator Calzert. I have the honor of opposing my own senator's bill.
First time?
And I wanted to say a number of things without repeating too much what the prior speakers have said, because I would agree that this is not a bill that will have an impact on public safety. That's not the issue. If we think about what happens with a bail schedule, and we're mostly talking about the lower level, even lower level misdemeanors, people can still be arrested post bail immediately off of a schedule. Most of those bond amounts are in the $1,000 to $2,000 range. That means they're paying a bonding company $100, maybe $200, and they're out. If they don't have that money, they're still in, and they have to go through the process of waiting in jail until such time as they can appear before a judge, who might set an OR bond but might not. The majority of people have that $100 or $200. They're out. So there's no public safety issue here in that respect. We're not preventing people from getting out who might be at a serious risk of reoffending, because they're getting out anyway under the existing schedules, because that's the vast majority of people. But those people who are poor cannot make that, even that small, relatively small payment, what for many of us might be a small payment, to a bonding company, and they're the ones that are sitting in jail. Those are the people that are affected by this, and I think I would ask the committee to consider why. What is the value? What are we getting out of it? Money goes to the bonding companies in that situation, but if there's no benefit to the public interest, to public safety, then we have the detriment to the system of the additional time it takes for deputies, sheriff's department to bring people to court, for courts to hear the question of bond, to make a decision. It does build in a considerable administrative time and expense. I would also just want to mention that we seem to be operating in an environment that is pretty shy of data on this. That is to say, if you looked at the bond schedules around the state for both municipal courts and other courts, we don't even know how many of them use an OR bond for particular types of offenses, when they do and when they don't. It would be helpful to know that before changing significantly Georgia law to prohibit a practice that many, many jurisdictions currently engage in and have engaged in for a long time. So I would encourage the committee to vote in opposition to this.
So we don't have any numbers, is that?
I beg your pardon?
We don't have numbers of the impact?
We don't know how many bail schedules around the state would be affected one way or another. There's not data on that. That's...
All right, thank you. You have a question, Senator Parent.
Thank you, Mr. Chairman. My question is, it would seem to me, just anecdotally, that a lot of the individuals affected may be mentally ill. And I was wondering if you had any statistics on that. If you're charged with, I know we have a lot of sort of low-level offenses where folks have mental illness. And I was wondering what percentage do you think that might be, or is it not a big issue?
We don't have any data specifically on that particular issue. There was quite a bit of data that was in the sense of the bondsmen that testified at the House hearing last week. It was all about some outlier cases, but there wasn't anything specific about, why this is necessarily needing it, other than it certainly seemed as an audience member that it's affecting their industry. And the concern of the people that are indigent, the people that are wrongfully accused, and it's the same effect as you may have heard the studies about children who remain in custody, or that when they are arrested and they stay in a facility for any amount of time, the amount of time that they're in affects the outcome for the rest of their life. In the same sense, that can have some effect on individuals who are adults who are arrested. It definitely changes their life, and the disproportionate effect on indigent. I think there's going to be a racial component, but we really don't have the statistics. There is, and admittedly, this bill has been improved since it was before the House committee, with some of the changes. It's just still there. In some ways, there's like this complete discretion to the sheriff. And, there's no rules on what the sheriff can do. How do we know how that operates? Well, you know what? I bet, Senator Parent, the sheriffs might respond to your call, but they may not respond to somebody else's call about a friend in need. And if we want to talk about treating people equally, that's certainly a concern that we have with regard to this bill and the need for it. And in like 17612, you're adding in felonies. Felonies are already covered in 176one. The whole setup for 17612 was bail restricted offenses. Now you're adding in local ordinances. It's a lot of concern about how this has been put together.
All right. Any other questions? Natasha Aladina.
Hello, my name is Natasha Aladina, and I'm an attorney with Georgia Justice Project. Georgia Justice Project is a legal nonprofit that represents individuals who have been charged with a crime in Metro Atlanta, and we also help remove legal barriers for justice-involved individuals, including record restriction. Georgia Justice Project opposes this bill for many of the reasons that have already been said, so I'll keep this brief. We oppose it because it penalizes the poor, and I'd like to just leave one image in the committee's mind. If you miss just 1 to 2 days of work and you are working a minimum wage job, you stand to lose a lot. You might get fired. That's going to affect your kids. That's going to affect your family, and start you down a downward spiral to where you might be that person who does need to go get a can from CVS just to keep your children alive. So again, we oppose the bill, and thank you for your time.
Thank you. Tim Smith. Go ahead.
Good morning. My name's Tim Smith. I want to thank you for giving me the moment to address you all. Unlike most people here, I am not an attorney. I am an individual who is vehemently opposed to this bill. The reason why I'm vehemently opposed to this bill is because this bill affects people who look like me. It affects black and brown people disproportionately. And the reason why it affects black and brown people disproportionately is because we just so happen to be the poorest people. And that's what this bill does. It criminalizes those that are poor. When I was in elementary school, my third grade teacher taught us that there was this document that our founding fathers created, the Constitution. And in this document, it guaranteed that all folks in this country have the same presumption of innocence. You are, as Law and Order, that TV show states, you're guilty, you're innocent until proven guilty. What this bill does, it says, if you're broke, busted, and disgusted, well, we're just sorry because you're screwed. And that's unacceptable. That should be unacceptable to everyone sitting here, that we don't want to be those people. We don't want to be that country. We don't want to be that state that leads the nation in being the highest number of folks on probation. So please, when you consider this bill, I want you to remember my face. I want you to remember all of those folks that will be negatively impacted because they can't afford their bail. Thank you.
Thank you. Senator Ligon.
Thank you, Chairman Stone. I think there's still some work that needs to be done on the bill, and I think we need to continue looking at it, and we're basically out of time. I move that we table the bill.
All right, is there a second? Second. All right, any discussion? Hearing none, all in favor signify by saying aye.
Aye.
All opposed, like sign. All right. I want to commend Senator Calvert and all the people that have been working on this bill. Obviously, what was passed last year needs some tweaking, and I look forward to working with all the stakeholders as we go forward. All right, that brings us to our last matter on the agenda. Hearing only on Senate Bill 221. Senator Harbin.
Good morning,
Now
Mr.
it
Chairman,
is
or afternoon, I should say.
It's afternoon.
Afternoon. Thank you, sir. Thank you, and the members of the Judiciary Committee.
Appreciate your patience.
Patience, yes, sir. Getting hungry as well. This bill has been really, for 3 years, we have we've been dealing with the issue. And my presentation this morning, or this afternoon, as you would tell me, is probably 20 to 25 minutes to really deal with the comparison of the federal law versus the state law of RFRA.
Well, we'll go until we've got an audience.
Well, we lost a great deal of those, and since we are not on vote for this, this is only a hearing only. I would like to work if there is a possibility to have another opportunity to present this.
I think that would be a wise decision.
Okay, well, I appreciate the chairman's understanding. I would like to do it at a time when we can do it properly. I think it's important for the people of Georgia. It's important for their First Amendment rights to be protected and for their religious freedom to be protected. And I would appreciate that for another time that we can make that happen.
We'll have a hearing on it. I'll get back with you.
Okay, thank you, sir. Appreciate it.
Thank you. There being no further business, the committee is adjourned.